This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, February 27th, 2024 at 2:45 in the afternoon. So we're back from a short break and here to continue our walkthrough of H121.
So let's soldier on. Getting to the meat of the act. Applicability section. I've made some updates here, both to address the new minor protection pieces, but also just to regularize or make clearer the sections, which sections are applying to a thresholded person and which are just applying to persons targeting residents generally. So you may recall, although this would probably be asking a lot, that the consumer health data piece had a strange, different kind of applicability section. I've amended this to incorporate that here. So no updates to the initial piece that the chapter applies to a person that conducts business in the state or produces products or services targeted residents of the state and that meets the particular thresholds related to the 1% or 0.5% plus 20% of revenue thresholds. But for sections 2420, 2424, and 2428, and that is 2420 and 2424 are both minor protection pieces, and 2428 is that consumer health data protection piece. So for these sections and provisions concerning consumer health data and consumer health data controllers, applies to a person that conducts business in the state or a person that produces products or services that are targeted to residents of the state. So that is removing those 1% and 0.5% thresholds for those particular purposes. So we don't have the thresholds for controllers dealing with consumer health data or for online products or services to minors. So that's what this is meant to get at. And it's also meant to be just a cleaner presentation. So you don't have to scroll through the entire act to figure out if a particular section does apply to you under some non-thresholded piece. Jumping to exemptions, Monique talked about that this may be kind of the big next consideration to come, is to work through these pieces and have folks testify to particular restrictions. But we did add a few here that I can speak to. So starting out with just adding government entities that are acting in the ordinary course of their operation would be exempt from this. Adding to the protected health information data level exemption piece to the extent that the business, that a covered entity or business association is complying with a DFR regulation, the sort of basic regulation, privacy of consumer financial and health information regulation. These may be pieces that you want to get testimony on as to what the content of those are. What I understand generally, but can't really speak that strongly to, is that some of the DFR regulations have more of an opt-in structure than an opt-out, and so may be more protective in certain instances than this bill would otherwise be. So the hope would be that the exemptions provided here would be at least as protective as what we're exempting to, just trying to not create duplicative or confusing, conflicting privacy regimes. But I think that this is a particularly complicated area, both because we can't possibly know all of the existing privacy regulations and figure out in what instances there are slight differences from what's here. Scrolling down, a couple of just citation updates to reflect that new addition of government entities. There are some additions to this subdivision 11. So information collected, processed, sold, or disclosed under and in accordance with the following laws and regulations. And we've added here at request Farm Credit Act, federal policy under this 21 USC 830, which is, I think this is related to Sudafed or particular chemicals. Pharmacies may have to maintain a particular list of folks securing certain over-the-counter drugs or prescription drugs. Again, this is a recitation of that same DFR regulation, but the previous exemption dealt with protected health information. We may consider as we move forward whether or not we don't need that other piece, given that we're including it here, but it's something we could think about aligning when we're kind of in a better position to understand the entirety of the exemption request.
Is it, so just both on the B on the Vermont regulation of the 1H 2001-1 and then the 2DF, the additional ones that John just went through, I would say that like, I would like to see us receive more testimony on these, if people are in agreement with that. They're kind of placeholders and that we didn't receive specific requests, so these were taken from the slideshow, that I noted as the presentations were happening, so I don't know that it's like best case, but we are attempting, we want to kind of cover those things that were requested, but we're not actually quite sure because we didn't receive specific language for those, so.
And not my position to direct the way the activity would be funneled, but to the extent that you're trying to achieve specifically data level exemptions, getting folks to send the regulations with some content as to what they are to make clear what that data level exemption would constitute would be useful. I know that many folks are obviously looking for entity level exemptions or some kind of hybrid where it's an entity to the extent that they comply with X. So I agree. I think testimony is helpful. And then if committed to data level exemptions, making that clear to folks so that they can bring the set of restrictions or regulations that they might need to substantiate those data level exemptions. Because otherwise, I think we had received, or like I have talks to DFR, for instance, and it's like they have useful things to say. But it'd be nice to be in alignment on specifically what we're trying to achieve, if it's data level exceptions. And those folks did reach out to me and say they saw the new draft and will be sending something helpful to align with this. So. Jumping down to 13, this relates to the last, this sounds sort of scary as you start reading it, but it's much more restrictive than it seems. This relates to the final definition of the definition section. So exempted would be personal data of a victim or witness of child abuse, domestic violence, human trafficking, sexual assault, violent felony, or stalking that a victim services organization collects, processes, or maintains in the course of its operation. So this is limited to those victim services organizations. However, I would say that the restriction here is to collects, processes, or maintains in the course of its operation. This potentially could be tightened up to if there are particular regulations that those organizations have to abide by. Otherwise, we're just saying that this kind of personal data, which is admittedly quite sensitive, would be exempt to the extent that one of these certain kinds of organizations has it. And you may want to tighten this one just to say something like collects, processes, or maintains in compliance with X. And I don't know what their restrictions or regulations would be, but something to think about.
And this one specifically came from Oregon, and it was just something that compliance kind of lawyers and advocates said might be a good idea for us to include, but that's what it's there. No specific request from Vermont.
Yeah, but I agree with Sean that I mean, without falling back on another statute that they have to follow to make sure that
Yeah.
that data stays.
Sure. Oh, yeah, maybe I'll try to find to see if we have something.
Yeah.
And part of that too, I think, would be substantiating what in the course of its operation would be, because it could be that the course of its operation is sufficiently restricted to where you're okay, but it's much better to have clarity regarding that.
I'm gonna throw a wrench, and I don't, like, this might be when we look at this after it gets passed and we kind of have to, right, like, a lot of these really only need exemptions. I'm gonna make people mad right now for opt-out. It's really what they need exemptions for. We still want them to minimize data. We still want them to do the other things, but we shouldn't require them to do to forget the data, forget the person, right, all of that, because they're maintaining the databases for a reason. So just for down the road, just planting the seed. Sorry if I made a lot of.
No, that's good.
I think the only thing that kind of complicates that is to the extent that exemptions are accommodating pre-existing sufficiently protective privacy regimes. If the sole concern there with adding an exemption is not to increase privacy burdens on organizations that are already compliant with some restrictive privacy regime, we're just trying to ensure not duplicating or complicating their efforts. I think in those instances, you would still have cause to exempt that. Yeah, so I'm not sure that that thought would necessarily apply to those.
Good point.
Yeah. Not to defend exemptions, but just to say
Yeah,
that
that's
that's,
a good point.
yeah. Last piece here, we have this piece to say that controllers, processors, consumer health data controllers complying with the particular requirements under COPPA shall be deemed compliant with attempts to obtain parental consent under this chapter. And we've included this, including pursuant to section 2420 of this title that deals with duties of controllers to minors. There's a piece there that deals with securing consent. So this is just a like cleaner way than including it in that particular section to say, if you're following COPPA parental consent requirements, you're going to meet those, you're going to be deemed to have met parental consent requirements under these sections. Jumping to 2418, there is one really meaningful change here. I did want to say, and you'll see this throughout the draft, that you'll see highlighted titles. I have tried to change these just to be simpler. I think it was nice to have what we had before to call out sort of everything that falls within a section. But I think it's maybe more intuitive to think about what the act as a whole is trying to do when you see these simpler titles. So instead of saying a whole set of semicolon separated clauses, consumer personal data rights, that's what the section is really about. So one new right has been added here, and that's subdivision 2. So a consumer shall have the right to obtain from a controller a list of third parties other than individuals to which the controller has transferred at the controller's election, either the consumer's personal data or any personal data. So this is a right to secure a list of third parties. Individuals are natural persons. That's what that's referring to which personal data has been transferred. The piece here that may seem slightly confusing, and if it is sufficiently confusing, we can try to change this. At the controller's election, that's not related to the fact that a consumer has a right here to obtain that list. It's that they have a right to receive a list of third parties. And then at the controller's election, the controller can determine whether or not that list is of third parties to which that consumer's personal data has been transferred or any personal data has been transferred. So depending on how they sort of maintain their records. But the gist of this is that a controller, regardless of the election that a consumer, regardless of the election that a controller makes, would have access to a list of third parties that either definitively or theoretically does have their data.
Is everybody okay with that piece? Okay. Well, let's find further. So make sure. No. Well, I just, this just came up in that, and for me and then John, like we talked through this too. So say like I'm asking a entity that I know has my data, like I subscribe to a certain thing. I can ask them to share either, like they can decide whether or not they're saying like, we share our data for everybody with these other companies, or we shared your specific data with these companies. So they get to choose kind of which, yeah.
Yeah, so the hope is that the consumer can get the kind of information they need, but this allows for some theoretical reduction in burden on the controller. So that's the only new right that's been added to the draft. You'll see some updates throughout to citations A1 through 5, which relates to exercise of consumer rights. Those have had to be updated with this new addition. So if you see some random highlighting, that's likely what it is. Like this, A6, that's what's up. So all of this section we've walked through before. There's nothing else new here. So we'll jump past this. Duties of controllers, again, just simplifying the title here. And if folks don't like the simplification, I'm happy to step and or think about other things.
Yeah.
So here's some new text. Actually, sorry, I do want to talk about a piece here. So this isn't new. There have been requests related to data minimization or other pieces. And I think that there's been some concern that our draft doesn't address data minimization or certain other principles that exist in other states. Unless I'm missing something from what other states are doing, and I don't think that's the case, What's happened is we just have a different style of presentation. So what we do is, like Colorado, for instance, will set out, here's duties of controllers, and it says one, duty of secondary use, duty of data minimization, whatever it might be. And ours is more a set of controllers shall do X, so requirements for controllers. That's subsection A here. And then subsection B is a controller shall not. So prohibitions, restrictions on controllers. So data minimization, that is addressed here in A2. A controller shall limit the controller's collection of personal data to only the personal data that is adequate, relevant, and reasonably necessary to serve the purposes specified in that privacy notice. So that is data minimization. If there's something out there on data minimization, we could add it, but this is where it would go. And we do have an existing concept of data minimization. That's something just, I think, more broadly for maybe folks watching online to hear. And then prohibitions on secondary uses. I know that this has been a particular concern, and I think the AG's office in particular wanted limitations on secondary uses. That actually falls under our subsection B. A controller shall not, and that's just one, process personal data for purposes that are not reasonably necessary for and compatible with the purposes the controller specified, unless the controller obtains the consumer's consent. And again, potentially you could build this out more, but this is the same concept of prohibition against or limitations on secondary use that exists in other states. So both of those concepts, and I would say at a high level, the animating privacy principles that have been driving state privacy regulations across the country are present in this draft. And I don't really know of a privacy principle that is not present here, that is present in another state. So I think that's just worth flagging. Of course, you could build things out more, but I just did want to make that clear. So what's new here? There is a slight tweak to the discrimination piece here. A controller shall not, subdivision 5, discriminate or retaliate against a consumer who exercises a right provided to the consumer under this chapter or refuses to consent to the collection or processing of personal data for a separate product or service, including by, and these were the pre-existing things they couldn't do, denying goods or services, charging different prices or rates for goods or services, or providing a different level of quality or selection of goods or services to the consumer. So this adds in retaliation, which might, you could imagine a court, potentially having a narrower concept of what discrimination is. Discriminate or retaliate against a consumer who exercises a right or refuses to consent. So, for instance, if they have sensitive data, a controller will need to secure consent for that processing. So if a consumer elected not to consent to that, this would prohibit a controller from retaliating against them on that basis for a separate product or service. Let's see. So this is sort of about construction of this section, how to read these particular terms. Shall not be construed to, and we're dealing with our financial incentive programs here. And there is a substantial proviso here that actually limits what was in place in the previous draft. So shall not be construed to prohibit a controller from offering a different price, rate, level of quality, or selection of goods or services to a consumer, including an offer for no fee or charge in connection with a consumer's voluntary participation in a financial incentive program, such as a bona fide loyalty, rewards, premium features, discount, club card program. And here's the new proviso. Provided that the controller may not transfer personal data to a third party as part of the program unless the transfer is necessary to enable the third party to provide a benefit to which the consumer is entitled, or the terms of the program clearly disclose that personal data will be transferred to the third party or a category to which that third party belongs, and the consumer consents to the transfer. So this is to say that even if you're doing one of these financial incentive programs, which the chapter is not meant to restrict, if a controller wants to transfer personal data to a third party as part of that program, they'll need to meet these conditions or one of these conditions. It's either necessary to enable them to provide that benefit, or they're disclosing that that data is going to be transferred and the consumer's consenting to the transfer. So this is a real restriction on what was in place in the previous draft. And again, kind of aligning with the more attempts to enhance consumer protection with the revisions. Another piece here was to boost up the sort of readability requirements in the privacy notice. So you'll recall that the controller is required to provide this privacy notice that sets out this whole set of details, which we've walked through in the past. We previously I think said something like has to be provided in 12-point font. I think that's what, it's just sort of an easy readability point. I think there are technological concerns with that and really it's a placeholder in the first place. So here's the new readability piece. Subdivision 2, the privacy notice shall adhere to the accessibility and usability guidelines recommended under the Americans with Disabilities Act and Section 508 of the Rehabilitation Act of 1973, including ensuring readability for individuals with disabilities across various screen resolutions and devices, and employing design practices that facilitate easy comprehension and navigation for all users, aiming for a reading level reflective of the average literacy skills of the user base. So this is meant to accommodate disabilities, different age groups, a much more fleshed out concept of what accessibility and usability would be.
That's a beautiful thing. I don't know why I was saying that's a beautiful thing.
I should have
Thank you.
Increased my Zoom or something while I was doing it to demonstrate
It just is really clear. It's, I really like it. Thank you so much. Anyway.
And maybe added piece about that, especially in design practices, is that the color contrast is actually a
Hmm.
very important ADA thing, and that a lot of people who don't have challenges with the color contrast piece of it is particularly helpful, plus added on to screens. So I think it's a very good section.
Nice.
Web developer might have written that.
More people, hopefully this could be actually pulled into other things we do in the legislature, because I think it is a very understood, I can't talk anymore, not as well understood importance from really making things readable.
I think the one thing that caught me and is just, probably in part me learning the job, this guidelines recommended under, I'm not familiar with how these acts work, and that may be, I'm assuming that that is the way, in fact, that they operate, is that they issue these guidelines. Hopefully this is acceptable to folks, but it was just something that I wasn't used to seeing as recommended under X law.
Does anybody need more on that? So when it comes to the usability guidelines, like when you have a website, like you're talking about with the color contrast and stuff, like people submit it and then you get graded on it. So certain like universities or states will have a different thing saying like you need an A grading or you need a AA grading or a AAA grading. And it's like, it's all there's just different standards for how much you actually adhere to the guidelines that are recommended. Yeah.
Just some citation updates to accommodate the new changes. So this piece, let me scroll up. So methods for submitting a consumer's request to a controller must allow a consumer or authorized agent to send a signal to the controller that indicates the preference to opt out by means of a platform technology or mechanism that subdivision E enables the controller to accurately determine whether the consumer has made a legitimate request to opt out. I highlighted this whole thing, although I think the change is not actually as big as the whole highlight. I think what we did is remove the restriction of determining residency, in part because consumer now accommodates visitors to the state. So that's really the change that's going on there. Okay, now we get our first entirely new section. So section 2420, duties of controllers to minors. A controller that offers any online service, product, or feature to a consumer, and again, just to call back, that is pretty intuitive, any service, product, or feature provided online that excludes broadband, telecommunications, or providing that physical product. So a controller that offers any of those products, services, features to a consumer whom the controller actually knows or willfully disregards is a minor, so that's someone under 18, shall use reasonable care to avoid any heightened risk of harm to minors caused by the online service, product, or feature.
I don't know if we flagged the origination of the whole minor section, so just want to say we originally, especially for people online, I know we've talked about it in committee. So originally we were thinking about pulling the minor piece from Connecticut SB3, and that was the plan, was a placeholder for that. I have been actively working with the lawyers who've been like helping to advise on this whole bill. Actually, we worked with Colorado to update that even more. So we went with Colorado, which is like the evolution of Connecticut's SB3 to be better. So if anybody needs a source for it, it's Colorado.
That's super helpful. And you'll recall that the previous draft had a placeholder for, and I think we called out specifically Connecticut's minor protections. I do think that it's not as if the Colorado and Connecticut provisions are largely different. In part, Colorado was useful because it aligns more with Vermont style of drafting. So in some ways, it was also just easier to accommodate. But it does sound like it's kind of the latest, and I don't know if latest and greatest is the right way to say it, but reflective of the concerns that have come before. So this first piece is saying controllers that offer these particular services, and there is a mental condition here that they actually know or willfully disregard is a minor, have to use reasonable care to avoid this heightened risk of harm caused by that service, product, or feature. For the benefit of the controllers, or just to ensure that they're sufficiently comforted by this statute, and this is consistent with Colorado, subdivision 2, in any action brought pursuant to section 2427, which is the enforcement piece, both AG and private right of action, there is a rebuttable presumption that a controller used reasonable care as required under this section if the controller complied with this section. So to the extent that they're following this section, they're going to be deemed, you could rebut that presumption, but there will be a presumption if challenged that they've met the requirement of subsection A, that they use that reasonable care. Unless a controller has obtained consent in accordance with subsection C, and again, that consent can be secured by complying with verifiable parental consent requirements under COPPA. Unless a controller has obtained consent in accordance with subsection C, a controller that offers any online service, product, or feature to a consumer whom the controller actually knows or willfully disregards as a minor shall not process a minor's personal data for the purposes of targeted advertising, the sale of personal data, or profiling in furtherance of any solely automated decisions that produce legal or similarly significant effects concerning the consumer. So these are the 3 pieces that you'll recall being called out in our 2418 or 2419. This applies to consumers generally, but the difference here is, as I tried to flag at the beginning, this is more of an opt-in rather than an opt-out when it comes to minors regarding these online services or products. So unless they've obtained that consent, the controller cannot process for these particular purposes. They have to obtain consent in advance of doing that. Whereas for consumers generally, not minors, it's presumed that those actions can be taken, that they can be processed for these particular purposes, and that you can then opt out of them. So slight tweak there that's suggestive of greater protections for minors, at least with respect to these online product services or features. In addition, that controller shall not process a minor's personal data for any purpose other than the processing purpose that the controller disclosed at the time the controller collected the minor's personal data, or a processing purpose that is reasonably necessary for and compatible with the processing purpose that the controller disclosed at the time the controller collected the minor's personal data. So this is pretty, this is a kind of data minimization piece here for minors. This looks awfully similar to what you see in the consumer protection piece generally, except that for consumers, that relates to collection, and this relates to processing. So slight difference there for minors. Shall not process that data, except for those explicit purposes they've given, or ones that have to be done, that are reasonably necessary for and compatible with the disclosed purpose.
So a minor is opting in, or a minor's guardian is opting in?
It will depend on their age. So if they're under 13 and are in that kind of COPPA land,
Yep.
they will need parental consent.
Yep.
13 or older, I believe that they themselves consent. And there may, I know we called out something related to the ages between 13 and 16, or from 13 through 16. But I think it's that they have the ability to, the kid has the ability to consent above 12.
And a processing purpose can't be to sell you more games? Processing purpose that is reasonably necessary for the purpose that the controller disclosed. Like, are we being too broad? Are we, right? Like,
So I'm not totally sure how to answer because it could be that a company's explicit purpose that they disclose to a minor is, I want to sell you more games.
Right.
Like, so that would be something that they could do. They disclose the purpose and then they can process, but they do have to secure consent to do this if it's through that online product or service. So this is in the opt-in regime.
Okay.
You could imagine lots of kids are likely to want to opt in.
No, my kids would. Names, please. Okay.
Yeah, that sounds great to me.
Yeah.
Stop.
You haven't left. Yeah.
So that's our data sort of minimization piece for minors' personal data, although it's processing rather than collecting. That controller shall not process a minor's personal data. This is subdivision 3. Process a minor's personal data for longer than is reasonably necessary to provide the online service, product, or feature. So that's not something you would have seen in the controller restrictions piece. This is new to minors. And again, those restrictions that you've seen in the consumer-related sections still apply to minors. It's not as if they aren't subject to those concerns. It's just that minors would be additionally subject to enhanced concerns around online products, services, or features, whereas those sections concern the processing of data by controllers and processors. So we're talking about two different kinds of activities going on, but a minor will be subject to protections under both sections just for different purposes. So I do want to make that clear that the addition of this doesn't somehow affect minors' protections under the pre-existing sections. That controller shall not use any system design feature except for a service or application that is used by and under the direction of an educational entity to significantly increase, sustain, or extend a minor's use of the online service, product, or feature. This is a pretty substantive one. Just it's easy to imagine that the sort of hook that's built into online services to keep people doing whatever they're doing, you now need an opt-in to use this kind of system design feature. I'm not totally sure how this would be implemented in practice, but this is consistent with what other states are doing. But a sort of like anti-addiction type provision. That controller shall not collect a.
It's kind of like, well, as someone who has very small children, it's kind of, when they want to buy the next show,
Yeah.
it pops up. And then right now, because we've set it this way, you need to know the code to, and the child almost knows the code at this point. That is how the technology works, is there would be some sort of pop-up to prevent just rolling into the next thing or buying the next thing easily. So.
I sometimes get, I can see my credit card purchases pop up on my screen and my grandmother has access to my Amazon Prime account. So sometimes I will see that like Gone with the Wind was just purchased.
It's solid film.
Your grandmother did a good job.
That controller shall not collect a minor's precise geolocation data unless it's reasonably necessary to provide that online service, product, or feature. The controller only collects the data for the time necessary to provide that feature, and so it has to meet all restrictions. The controller provides to the minor a signal indicating that they're collecting the precise geolocation data and makes that signal available to the minor for the entire duration of the collection of the precise geolocation data. So this is a pretty substantive piece here, needing opt-in for collection of that geolocation data, which again, we're talking about the 1850 piece, and we are also talking about the additional new language that we highlighted regarding data derived from devices that are used or are intended to be used to locate a consumer within that radius of 1,850 feet. And of course, the requirement that you provide a signal indicating so the minor is aware that that's what's going on. Subsection.
In these scenarios, I'm just trying to think of real life scenarios. So and particularly for minors, this is specific to each controller. So even if someone on their device, I don't know, what is this like Geo around Pokemon Go or whatever, for example, really weird scenario, but like, let's say that you do consent to using that, another device on another app on your phone or something can't piggyback onto that consenting of geolocation.
I think that's fair to
consenting,
say.
each one would have to individually consent. So because, people are on the go and other things, I don't know, I feel like certain apps stay open and I just want to make sure that they all have to be individually engaging with the consumer, in this case, and particularly with minors, and that there's no piggybacking allowed.
I think that's right. I'm trying to think of what the like technological links would be that would allow this sort of piggybacking. Like in this particular instance, when we're talking about geolocation data, for any instance in which your location would be tracked in this particular way, you would have to have that light on or some indicator, regardless of if you've already consented. That's a provision that's still in place.
I also
And-
wonder about like find your phone apps, all the things that can be, you have to sort of consent to, just to make sure that people don't knowingly do a universal opt-in. That may not even be the right word to use it, but I think with often sometimes you get alerts that you have to go back and reopen or reauthorize a tracking thing for a certain app. And I just want to make sure there's enough protections that we aren't inadvertently allowing things to be opened up because one, you think you're consenting to this one
Mhm.
app or whatever. But then other ones get to the back door.
And-
Technical terms for this.
Not directly responsive to what you're saying, but I just realized that I misspoke in describing this particular subdivision 5. The controller would have to secure consent if these 3 conditions are not met. They wouldn't have to secure consent to collect that miner's precise geolocation data if it's reasonably necessary for that service, product, or feature. They collect only as necessary for that feature, and they provide that signal indicating. So it's an unless. So they shall not collect that data unless. And while that's not securing consent, it's making very clear that a miner is doing so. Like you can't not be aware. I mean, that's the idea, is that it's going to be front and center for the miner what is happening. Now, whether or not they respond in appropriately privacy protection ways is unclear, but I did want to correct because I think I stated this more strongly than it actually is. Subsection C, a controller shall not engage in the activities described above, that section we just walked through, unless the controller obtains the minor's consent or, and this is the piece we were talking about earlier, if the minor is a child, the consent of the minor's parent or legal guardian. So that's under 13. And again, the verifiable parental consent requirements under COPPA would suffice to meet the consent requirements of this statute. Subsection D, a controller that offers any online service, product, or feature to a consumer whom that controller actually knows or willfully disregards as a minor shall not employ any dark pattern. We've talked about this before. This is methods of sort of deceptive securing of consent, kind of fake logins or just clicking out of, Xing out a window and you've consented to something. And does include anything that the FTC deems to be a dark pattern. So when it's a minor being offered this online service, product, or feature, a controller shall not employ a dark pattern or, except as provided in the subsection we'll come to, offer any direct messaging apparatus for use by a minor without providing readily accessible and easy to use safeguards to limit the ability of an adult to send unsolicited communications to the minor with whom the adult is not connected. So meant to provide protections against unconsented to interactions with adults. However, there are instances where this would be permissible. So this does not apply to an online service, product, or feature of which the predominant or exclusive function is 1, email, or 2, direct messaging of text, photographs, or videos that are sent between devices by electronic means where messages are A, shared between the sender and the recipient, B, only visible to the sender and the recipient, and C, not posted publicly. So this is meant to get at a restricted, sort of consensual 2 parties agreeing to communicate these things in a private way. That's not meant to get captured in these restrictions on online products, services, or features. And that's just talking about that they shall not offer this kind of service. So jumping to 2421, this is just retitling duties of processors for simplification. I don't think there's anything new. Oh, there we go. There's some very small tweaks here. This subsection B previously said that a processor was required to secure a contract or something to that effect. This has been changed to say a processing by a processor must be governed by a contract between the controller and the processor. The reason for this is that the obligations of the chapter really provide to controllers. So we're subjecting controllers to particular requirements. So it was sort of inconsistent with that to subject the processor to an independent requirement to secure those contracts. It's the controller is meant to be carrying out these obligations. So same effect, but different. It's applying to a different party rather than the processor. It's applying to the controller. There's another piece here that's sort of similar to this. That contract has to require the processor to enter into a subcontract with a person the processor engages to assist with processing personal data on the controller's behalf, and in the subcontract, require the subcontractor to meet the processor's obligations concerning personal data. What this previously said was require the subcontractor to meet the processor's obligations, something like meet the processor's obligations under the contract between the processor and the controller. So in effect, what the previous draft did is said that the contractual provisions would be identical between what exists between controller and processor and what exists between processor and subcontractor. That's not the way that would actually work. What you would want is for the subcontractor to be subject to the obligations that the processor has toward that data. So that's what this change does. This is not a lessening of standards. This is just kind of cleaning up what was meant to be in place in the prior draft. This is a new piece to what would be required under those contracts. It will prohibit the processor from combining personal data obtained from the controller with personal data that the processor either A, receives from or on behalf of another controller or person, or B, collects from an individual. So this is a kind of no intermingling provision. If you're receiving data from elsewhere, you're not going to mix it with that personal data that you're getting from a controller. So I know there's been some concern about like loopholes or accidental ways that data is going to somehow escape the protections of this act. This is meant to be tightening up in a way that ensures that pools of data are treated separately and that we aren't getting into odd interactions or intermingling.
Yeah, and one thing here, one reason for this is so if I have data and it gets mingled with Edie's data and then I ask for delete, but they're like, oh, we mixed it with everybody else. We can't tell what is yours anymore. That's like a reason for this.
I was thinking about it in a totally different way. I appreciate that. I was wondering, so combining personal data obtained with personal data received from somebody else gives you a broader picture, right? If you're data minimizing and then you get data minimized for one purpose and data minimized for another purpose, you get a bigger. So I'm wondering if we need to have publicly available data, like you're not allowed to mix it with that either.
Yeah, we did have a piece in there at one point. I don't remember if we still have that. I'll just flag it and make sure if we don't.
Okay.
That was the piece that we
A
had.
prohibition on intermingling with
Yeah,
publicly available information.
if we're trying to keep data minimized, we shouldn't be allowing. Yeah.
We did have that at some point.
Okay.
So we
And
can,
it might
I'll
be
flag
somewhere
it to
else
like
in
double
here.
check. Yeah, but I'll make sure to double
And I
check.
don't know what the complications are
So-
around that.
Just quick thoughts on that are that we're dealing with processors here who are obligated to assist the controller in particular specified ways. And the data minimization principles and pieces apply to the controllers themselves. So they have a set of purposes that they set out in that data privacy notice, and that they're obligated to follow the minimization piece with respect to that. So this isn't to say that that might not be a helpful thing to add. I would obviously want to think about it more, but the particular concern that the processors are somehow escaping the data minimization piece that applies to the controller is, I think, not as grave a concern as it might seem. Like that principle should flow through to the processors, I guess, but maybe something to think about. Because the processor is only acting as a processor to the extent that they're complying with that controller's instructions. And because the controller is obligated to only do things insofar as they further the particular purposes, which is what data minimization in this piece means, then therefore, to the extent that the processor is following these instructions, hopefully they are satisfying what the act already constitutes to be the minimization piece. And to the extent that they aren't, they're then deemed to be a controller and they become subject to additional obligations and restrictions that they weren't otherwise directly receiving. Does that?
Yep, thank you. Are they a processor? Are they a controller? And what, yep.
And you've seen those pieces about when does a processor turn into a controller. And I think we'll come to some of that. And we have a particular piece as well that is the same, but for minor protections that are added here. So 2422, duties of processors to minors. So wholly new section. A processor shall adhere to the instructions of a controller. I will say this looks a lot like, it's almost exactly like the duties of processors generally, but this is specific to the minor protections pieces. So that's why this is here. Adhere to the instructions of the controller and shall assist the controller in meeting the controller's obligations under the duties of controllers to minors, and 2424 is duties of processors. Sorry, data protection assessments for minors. Assist in meeting those obligations, taking into account the nature of the processing, the information available to the processor by appropriate technical and organizational measures, and whether the assistance is reasonably practicable and necessary to assist the controller in meeting its obligations, and provide any information that is necessary to enable the controller to conduct and document data protection assessments pursuant to section 2424 of this title. So that's that, again, data protection assessments for those heightened risk of harm to minors. A contract between a controller and a processor must satisfy the requirements that we just walked through. So those apply broadly, whether minors or consumers. Generally, those contracts are the same kinds of requirements in both places as regards processors. Nothing in this section shall be construed to relieve a controller or processor from the liabilities imposed by virtue of the controller's or processor's role in the processing relationship as described in those sections. Again, this is all tracking what is the case for duties of processors generally, but this is specific to the minors piece. And D, determining whether a person is acting as a controller, and we were just talking about this, determining whether acting as a controller or processor with respect to a specific processing of data is a fact-based determination that depends upon the context in which that personal data is to be processed. A person that is not limited in that processing pursuant to controller's instructions or that fails to adhere to the instructions is a controller and not a processor with respect to a specific processing of data. A processor that continues to adhere to a controller's instructions with respect to a specific processing remains a processor. So that's that piece about adhering to instructions. If a processor begins alone or jointly with others determining the purposes and means, the processor is a controller with respect to the processing and may be subject to an enforcement action. I will say one thing we could consider, there's nothing substantively at issue here. These are worded slightly differently between how these two sections work, and at sort of final stage when all content is agreed, we could just conform the usages so there's no question as to whether or not there's meant to be some difference in content between the two, but you'll see that they look awfully similar because they're trying to get at the exact same kinds of things, just for different purposes. Section 2423, again, just retitling, data protection assessments for processing activities that present a heightened risk of harm to a consumer. And in part here, the simplification of titles is also meant to get at the fact that we've now added in through the new minor protections pieces, sections that look an awful lot like the sections that precede them. So previously we just had data protection assessments generally, and maybe some other clauses as part of that title. But now that we have data protection assessments offered for different purposes, it's useful to have these call outs to what the protection assessment is for in that section heading. So you can just quickly scan and see, oh, here's my obligations with respect to consumers generally, and here's what I have to do for minors in particular. New piece here, data protection assessments. This was a relatively, I don't know if thin is the right word, but the entire content of what those data protection assessments would need to involve was contained here at this subsection B. We've added a little bit more content, or you guys have added a little bit more content to say that that assessment shall identify the categories of personal data processed, purposes for processing, and whether the personal data is being transferred to third parties. The other piece about identifying and weighing the benefits remains in place.
I had a question about this back when we first did this. And I appreciate trying to build it out a little bit more. I wonder if does this exist anywhere else when you were researching that another state has actually defined the parameters around this protection assessment thing? Rather than make it clear.
So
Not that you make it clear.
so the identify and weigh benefits piece is what other states are doing.
Okay.
I'm not sure the source of this
Yeah.
section A or subdivision A. But this piece, other states do have content as to what this data protection assessment would be. And when we get to the consumer protection piece, you can see exactly what Colorado did, to the extent that that's helpful, because you could, if you find pieces of it to be preferable, you could use those here as well. So it'll be something to see for examples.
I'll just add, so we didn't have this in anything previously. This is something that came, so there's a, basically like Epic and Consumer Reports and stuff have been working with Connecticut kind of as a base, but also like the federal bill that didn't pass tried to take some stuff like further. And so there's pieces in there that are trying to just like either clear up or tighten up expectations. And so they're working with Maine and Maryland, and Massachusetts on these changes right now. And so they sent those like documents and so tried to incorporate little pieces here and there that seems to like help clarify things. So that's where that came from, but
No, it's
Yeah.
helpful because I think that my biggest, in our first walkthrough of this was just, if something were to go wrong and the AG's office had to do some sort of investigation, just
Totally.
making sure that we had some minimal amount of definition or standard of what these, protection assessments were supposed to be, that they do when a big moment happens when you're handling people's data and
Yeah.
like, what do we mean by that? Is, I was being a little, extreme by saying it can't be on the back of an envelope, it has to be defined in some way, shape or form. So that's, this was where my original question was, so, yeah.
And to cut against what I just said, but not to contradict it, just to say that it's something to think about, is that you might think that different kinds of data protection assessments are appropriate depending on the severity or risk of the underlying conduct which is being looked at. So to the extent that the minors protections piece is broader, there may be reasons that that is the case that you may not want to pull in, because to the extent that you could flesh out the data protection assessments so significantly that they become burdensome in a way. So that's the other end of where you can end up going. Not saying that you're at any risk of that, but that's just kind of the other side of the coin to think about.
It is interesting though with minors too, and then
Mhm.
it becomes, do they age as much things to, anyway, so,
Mhm.
yeah.
So here we go, section 2424, data protection assessments for online services, products, or features offered to minors. Subsection A, a controller that offers any online service, product, or feature to a consumer whom the controller actually knows or willfully disregards as a minor shall conduct a data protection assessment for the online service, product, or feature. And there is a difference here that I wanted to call out. So let me scroll back up. The condition for a data protection assessment in our general section in the draft that we had previously was for each processing activity that presents a heightened risk of harm. And that includes this particular list. So that's what triggers data protection assessments for that general requirement. For the minors piece, this is a controller that offers that online service, product, or feature and actually knows or willfully disregards the consumer is a minor. They have to conduct that data protection assessment for the online product, service, or feature. And I'll need a comment here. Let's see. So there isn't a built-in piece regarding above it required this heightened risk of harm. This is just if a controller is offering any online service, product, or feature and is aware the consumer meets this category. That's it. That's what triggers the data protection assessments. The way that risk is built in is below in the content of the assessment itself. So that is one difference in terms of what triggers that obligation to conduct an assessment. So what does the controller have to do? Conduct that data protection assessment in a manner consistent with the requirements above. So we talked about that previously. I can scroll up to that if you wanted to go through that again, but I think we've sort of hinted at it as we talked about the content. And that addresses, and here's the unique pieces of this, address the purpose of the online service, product, or feature. So that's consistent with the new edition that you saw above. The categories of a minor's personal data that the online service, product, or feature processes. So again, that's consistent with the new highlighted language above. The purposes for which the controller processes a minor's personal data with respect to the online service, product, or feature. Again, consistent with above. And this piece is new, any heightened risk of harm to a minor that is reasonably foreseeable result of offering the online service, product, or feature to a minor. So this piece is unique to this, and you can think of it in part a function of the fact that we just talked about, which is the assessments attached when a controller is offering these services, products, or features to minors. So there was no requirement in the initial stage to trigger the obligation to conduct any sort of risk assessment. That is built in here. They have to assess any heightened risk of harm. And I'm happy to jump back to the definition section to talk about heightened risk of harm if you guys need to see that again, but don't have to. This is also a unique piece of this. A controller that conducts a data protection assessment, that's subsection B, pursuant to subsection A, shall review the data protection assessment as necessary to account for any material change to the processing operations of the online service, product, or feature that is the subject of the data protection assessment. That is not a part of the general data protection assessment requirement. This says that you have to review to account as necessary to account for material changes to that processing. And I do think that there is more content to as necessary than it just sounds, because it is tied to account for any material change. So when a controller is, at least theoretically, when a controller is changing that online service, product, or feature in a way that's materially altering their processing operations, you're going to need to review again that data protection assessment to see if there's something that's changed. And again, it's going to require you to look at that heightened risk of harm. So you will, hopefully, the idea is that it's going to incentivize people to notice if you're increasing that risk of harm with any new changes to your operations. This is also a nice piece here that is additional protections in the minor piece that aren't above subsection C. If a controller conducts a data protection assessment or a review and determines that the online service, product, or feature that is the subject of the assessment poses a heightened risk of harm to a minor, which is a required component of that assessment, the controller shall establish and implement a plan to mitigate or eliminate the heightened risk. So this isn't just a way of eliciting that something is subjecting minors to increased risk in the event that the controller detects that that's happening, either as part of the initial review or as part of, either as part of the initial assessment or as part of a review that comes upon material changes to the processing. If they detect that there is any heightened risk of harm, they have to then take steps to implement a plan to mitigate or eliminate that risk. So this is a pretty meaningful piece. The next sections largely track what is above. So the AG, Attorney General, may require that a controller disclose any data protection assessment that is relevant to an investigation, and the controller shall make that data protection assessment available. The Attorney General may evaluate the assessment for compliance with the responsibilities set forth in this chapter. Data protection assessments are to be confidential and exempt from disclosure and copying under the Public Records Act. This all tracks what is above for data protection assessments generally. To the extent any information contained in the data protection assessment disclosed to the Attorney General includes information subject to attorney-client privilege or work product protection, shall not constitute a waiver of that privilege or protection. And sort of administrative pieces here that you could have a single data protection assessment to address comparable sets of processing operations, including similar activities. And if the controller has conducted an assessment for complying with another law or regulation, and it's deemed, the data protection assessment shall be deemed to satisfy the requirements under this section if that assessment is reasonably similar in scope and effect to the one that would otherwise be conducted pursuant to this section. So we've talked about these pieces above, but happy to discuss more if needed. And then we've had this piece here just to align with the new effective date, could push this out further, but I think generally what we've seen in states is that this aligns with the effective date. So basically this is just not meant to be retroactive when this comes effect. Only data protection assessments for processing activities created or generated after that date. And then we have this maintenance piece. A controller that conducts a data protection assessment pursuant to subsection A shall maintain documentation concerning the assessment for the longer of 3 years after the date on which the processing operations cease, or the date the controller ceases offering the online service, product, or feature. This is different than what's done above, which requires, I want to say, 5 years from maybe the point of taking the assessment. I think I noted this last time. Both of these provisions offer ways of maintaining those data protection assessments, which are presumably useful for investigation pieces. But I would imagine that companies will also have an incentive to have data protection assessments in place to the extent that they're going to help them defend themselves if they're subject to suit. Because if they can produce data protection assessments that show why they give good reasons for why they did what they did. So just to say that, it's good to have these time restrictions to ensure that they're being maintained, but they may also have independent sort of economic reasons to hold on to these pieces as well. A few tweaks we're almost there. 24, 25, de-identified or pseudonymous data. Again, we talked above about reasonable measures. This replaces reasonable measures. A controller in possession of de-identified data shall follow industry best practices. This just tracks what you saw, the updates to the de-identified data section. So nothing we haven't talked about today. A controller that discloses or transfers, not a really substantive update, but aligns with some of the references throughout draft, which reference both concepts. I think, somewhat duplicative, and you could do different ways of doing this, but I see no issue with this approach. Just making sure that we're capturing transfer of that data. Some retitling here and a little bit of change. Section 2426, construction of duties of controllers and processors. This is kind of a guide as to how to read, how restrictive, what are you limited in doing under this chapter. You could make an argument that this is sort of a nice thing to have at the start of the chapter for someone just diving in to see, but given that the content of what the restrictions are isn't clear until you've read the chapter, I think there's some logic additionally to including this where it currently is. So how to think about the controllers, processors, or consumer health data controllers obligations. We've introduced a restriction here, and this is meaningful. This is a meaningful addition to the previous piece. Previously, we said that the chapter shall not be construed to restrict those entities' ability to comply with state law, say. So that's what would be under A1. Now we're saying it's actually more restrictive than that. It will not be construed to restrict their ability to process personal data, to transfer non-sensitive personal data to the extent reasonably necessary and proportionate to, or to transfer sensitive data to the extent strictly necessary to comply with. So that means this is only telling folks that they're safe in complying with these things to the extent that what they're doing is acting in accordance with this. So if they're transferring sensitive data to comply with federal, state, or municipal laws, they're only going to be able to do that to the extent that it's strictly necessary to do that. They don't have broader freedom to kind of just deal with sensitive data however they want in the context of compliance with those laws. So this is a tightening up that is meaningful. Shall not be construed to restrict their ability to carry out obligations under a contract. And this 2421B is just that section that describes the content of those contracts. Carry out obligations under a contract for a federal or state agency or local unit of government. I'm not entirely sure that this has to be included, but it is a helpful call out. The federal, state agencies, local units of government may be exempt from under that new exemption that we've added, in which case you could imagine, I suppose, a processor or someone who is under contract with that exempt agency processing data and then being worried about being subject to restrictions here. This is helpful to call out that you'll be safe if you're acting under a contract with those entities.
We've already heard that.
Did I say that all loud? No.
Shall not be construed to restrict their ability, the entity's ability to provide a product or service specifically requested by the consumer to whom the personal data pertains. This is just clarifying. This is definitely the content that we were meant to capture in the previous draft. It's not that if one consumer requests a product, that the controller can then do whatever the hell, whatever they want.
At 4 o'clock.
Yeah.
Feeling comfortable.
Yeah.
I had my intake. This is just clarifying. It's meant to say that it's not any request for products permits general disclosure of personal data. It's specific to that concern. Shall not be construed to restrict those entities' abilities to, and this is consistent with what was in the previous draft, these highlighted updates, but it makes clearer and separates out in a cleaner way. So prevent, detect, protect against, or respond to a network security or physical security incident, including an intrusion, or trespass, medical alert, or fire alarm. So this is just kind of building out the content of what that was before. It just said security incident, I believe. Or prevent, detect, protect against, or respond to identity theft, fraud, harassment, malicious or deceptive activity, or any criminal activity targeted at or involving the controller or processor or its services. This is conceivably a restriction on what was in the previous draft, that it is limited to criminal activity or these other kinds of activities. targeted at or involving the controller or processor or its services. I do think it's consistent with what the intent of the existing subdivision was, that this was not meant to get at criminal activity generally. It wouldn't afford the controller the ability to not comply with the chapter otherwise, but this makes clear it's about those things as targeted at the controller or processor. Shall not be construed to those entities' abilities to deliver a communication that is not an ad to a consumer if the communication is reasonably anticipated by the consumer within the context of the consumer's interactions with the controller. Deliver a communication at the direction of a consumer between the consumer and one or more individuals or entities, or ensure the data security and integrity of personal data. I don't see issues with these additions, sort of meant to accommodate sort of expected behavior.
Clarity.
Yep, and not accidentally prohibit sort of normal, secure behaviors. Subsection B, the obligation, so this deals with internal use. There are some new pieces added here. Obligations imposed shall not restrict a controller's or processor's or consumer health data controller's ability to collect, use, or retain data for internal use too. And we did strip out a previous subdivision 4. I think that was something that the committee agreed to, but if you're interested, we can flip to that, or if you care to check and just see that that was stripped out. There was a previous subsection 4, but we did add new pieces. Process the data as necessary to perform system maintenance for diagnostics, so that's permitted. Internal uses, or protect against spam. Both of those are new permissible uses for that internal uses. Personal data processed, this is subsection F. Personal data processed by controller or consumer health data controller pursuant to this section may be processed to the extent that the processing is for non-sensitive data reasonably necessary and proportionate to the purposes listed in this section. So this is talking about personal data that is processed either for those internal use pieces or for that long list of, say, compliance with laws, facilitating a contract, whatever it might be. So to the extent that folks are operating under this section, they can process to the extent that it's reasonably necessary and proportionate to the purposes listed in this section. That's what was in place in the previous draft. Or, and we have this heightened piece now here, in the case of sensitive data, strictly necessary to the purposes listed in the section. So enhanced protections specific to sensitive data, which again, just to hit home, we do have a broadly expanded definition of sensitive data in this draft. So this will pick up things. But again, this is for internal use and that laundry list of things that are permissible under this section. 2427, enforcement, private right of action, and attorney general's powers. There have been some tweaks here. In subdivision A2, we've added a sort of liquidated damages piece. We haven't, spelled out a full schedule here, but just to say that a consumer harmed by a violation may bring an action in superior court, so this is your private right of action, for the greater of 1,000 or actual damages, injunctive relief, punitive damages. So this imposes a floor. If you are able to if a consumer is able to successfully bring an action, they are entitled to 1,000 or actual damages to the extent that they're greater. And this goes somewhat to the concern that we talked about, and also the HLS folks talked about, where spelling out some definitive consequences for violations is important for these to have any actual effect in practice. The next piece here in B1, there was previously there was kind of a rollout period that created a process in which the AG would issue a notice of violation, provide for the amount of a 60-day period in which cure would be possible if it was deemed that cure was possible, and only after that would the AG bring action. I think you guys heard testimony or had discussions that the AG was concerned that in particular instances during this rollout period, they might actually be prevented from responding adequately to particularly dangerous behavior. So this has made this more discretionary. It's eliminated that kind of initial period, which had a sunset, and just said that the Attorney General may, prior to initiating an action, issue a notice of violation. So it grants them discretion to do so. It doesn't make it mandatory. And then in determining whether to grant that ability to cure, I think we had, oh, no, we didn't add a new piece. Okay. Thought we'd add a new piece. So same provisions there as to what the AG needs to look to in determining that. 24, 28, this is our last section of the Data Privacy Act as a whole, and then we can jump quickly. We'll go through it pretty quickly, the data brokers piece. Don't think any, yes, so we do pick up the change to 1,850 feet for geofences. And we've added a new piece here. This was geofences, and just to scroll back up, no person shall under 24, 28 use a geofence to establish a virtual boundary that is within this expanded range, 1,850 feet of any, and now we've added this healthcare facility, which was the citation that we talked about previously, mental health facility or reproductive or sexual health facility. So new facility added here.
So I just think, if we look at the statute for pharmacy and decide we want to do it, this is where we would do it if,
Do you want to talk about the, the, so the Consumer Protection Act has no cure period. This bill adds a 60-day.
consumer protection, right, says a private right of action on it. Ours adds a cure period of 60 days.
I want to make sure that everyone understood that.
A permissible cure, like the
Right.
AG will have discretion.
Yes.
We don't have a kind of in place for 2 years, you're getting a 60-day opportunity every single time. It's more discretionary than it was in the previous draft, but there is still that opportunity to cure available in the instances in which the AG feels that it's appropriate.
Thank you. I just want to make sure
Yeah.
that was on the table.
I'm gonna do this real quick because we can get through this.
It's, there's
Yeah.
like too much, I feel like after.
Public education and outreach. We've added as a requirement to the education piece for controllers and processors. So this is businesses that they address enhanced protections that apply to minors. So that's just following from the new changes added. And now we have a new piece here to talk about education for consumers. I know that that was one of the particular concerns, is that consumers may not be aware of the rights that they have. So this subsection C is to create a comprehensive public education and tasking, again, the Attorney General's office and the Agency of Commerce and Community Development to implement a comprehensive public education, outreach, and assistance program for consumers to focus on. And then we do have a separate set of concerns because this is specific to what consumers would be interested in. And I'd certainly be open to suggestions that you guys may have to how to build this out. But these are suggestions. With the program focus on rights afforded consumers under the Act, including the methods for exercising and the opt-out mechanisms, the obligations that controllers have to consumers so that consumers know what sort of behavior they should be encountering or expecting, the different treatment of different groups, so children, minors, and other consumers, including the different consent mechanisms, including that copy piece that we've talked about. Understanding a privacy notice, you can imagine that these are going to be potentially lengthy documents and maybe technical language. I know there's usability and readability requirements, but something to help folks understand what should be in that privacy notice, that it should set out those particular purposes and afford them opportunities to exercise their rights. The different enforcement mechanisms available under the Act, including that private right of action, which they would have the right to exercise in any other matters those entities deem appropriate. The last piece here, subsection E, this is a requirement to, very general, and you could build this out much more, but to on or before, so effectively about a year and a half after rollout, assuming we stick with the July 1st, 2025, on or before that date, AG shall assess the effectiveness of the implementation of the Act and submit a report to this committee and Senate Economic Development with its findings and recommendations, including any proposed draft legislation to address issues that have arisen. Again, this is something I would welcome if we want to build this out more, although the Attorney General's office may have ideas as to what they would like for the content of this to be. But this is a way of kind of checking in on status and seeing if tweaks need to be made. And then we're so close. We're gonna get through this. Something to broker data. We do add in controller, consumer health data controller as part of the definition of business. This does mean broadly that subchapters that are not addressed in this bill, so that's things like there's old statute to say protection of Social Security information. Because that applies to businesses, that will now pick up controllers and consumer health data controllers definitively under this proposed change. However, that said, those folks are most likely already getting picked up by the definition of business because they're probably commercial entities. But to the extent that they are not, they would now be subject to those additional subchapter restrictions in place. Aligning a bit the definition of consumer here, it's slightly different because we say not just one who's a resident of the state, but an individual who is in the state at the time a data broker rather than controller or processor, as we talked about above, to align with the data broker piece here. So a consumer is an individual residing who is a resident of the state or who is in the state at the time a data broker collects that data. Conforming changes here. And just a few things. Try not to cause motion sickness. Data broker may provide notice of a security breach involving broker personal information to a consumer by 2 or more of the following methods. I did want to call out, so what this does is previously this was just a requirement for 1 or more methods, so written, electronic, whatever it might be. I did want to call out that there's a slightly different formulation of how you could do this. If you look to the security breach for data collectors, which is part of the same chapter, but is not addressed in this bill. They talk about direct methods of notice and public methods of notice. You could mirror something based on that. This statute largely follows that, but you could have something here to say one method from this piece, directed to individuals, and one method from the public piece, just to ensure. So it's something to think about.
Most people don't know a data broker has their data, so that public might not be as valid in the situation.
And
Many.
right, and the
Yeah,
public
but
piece.
I was all in and then I had sorry, go ahead.
No. I mean, I will say if you were required to provide 2 methods and one of them was public and it had no effect, you would still get the effect of the individual notice. But there is a new public piece added here, although it's not called that because this isn't following that other statute. Notice by publication in a newspaper of statewide circulation. I think the more generic language that's used for data collectors is statewide or regional media, something to that effect. So that's another way you could do it. And then there actually is a piece that deals with nationwide disclosure, and that's something you could think about. So if you're interested in these pieces, look to the data collector security breach piece just to see what that could look like. Lastly, we have some tweaks to fees. Section 2426, boosting the annual registration fee for data brokers from 100 to 550. This
If Chase is fine.
This highlighted tweak you see here is really just a conforming change because this doesn't contemplate an absence of opt-outs. I don't think these pieces are necessary. All that needs to be disclosed is the method for opting out and whether they're permitted to use a third party. These would apply more when you had a restriction on what could be opted out. Again, increase in civil penalty here rather than the registration fee. So a data broker that fails to register is liable to the state for a civil penalty of increase of $75, $125 for each day fails to register. Other provisions have remained in place from the previous draft. The last piece here, 2448, this is meant to get at some of the issues with alignment between compliance with opt-out provisions between the Data Privacy Act and the data brokers piece. These are separate chapters, so we're not talking about under the same chapter. And this is to say that if what was in the pre-existing draft was a requirement that data brokers comply with a request to opt out under A, within 10 days after receiving the request, you'll note that under the Data Privacy Act, we have this broader 45 days. We have a built-out process for appealing if a controller is unable to comply with that requirement. So this is maybe a simple way, and it's something we could think about more, but this is to not withstand that and basically to say that to the extent that you are a data broker, so even if you are a controller, but you're operating in a data broker context and are therefore subject to this act, you're going to have to comply with the 10-day restriction just like any other data broker. What we may need to do, we could consider whether there should be some call out in the Data Privacy Act to reference this, just to say, hey, you're on notice that to the extent that you're operating as a data broker, there's actually an accelerated compliance provision piece for you. But this is meant to ensure that the tighter restriction is in place as contemplated under the previous draft. And then we have just some permissibility about when to develop that online form for data broker opt-out list by January 1st, 2026, and some provisions to give some more content to the data broker opt-out list. So security procedures and practices to protect information from unauthorized use, disclosure, access, destruction, including technical safeguards appropriate to that information and the purposes for which it will be used. That the Secretary of State cannot charge a consumer to make an opt-out request, so a pretty meaningful piece for consumers. And then lastly, that opt-out list include an accessible deletion mechanism that supports the ability of an agent to act on behalf of the consumer so that the consumer would not themselves have to go through this. Although I will say, if what the general opt-out is meant to accomplish is to only need to do one opt-out and then otherwise be free from these things, it's nice to have an agent, but that's also not an incredibly burdensome task for an individual consumer to do. And that, I want to say, oh, there we go. Effective date, July 1st, 2025. That's it. That's everything. We did pretty good.
Good,
Really good.
good team spirit, John.
I just wanted to highlight something because when we have the different date, different timeline for
Mhm.
data brokers to provide, to abide by the rules or
Mhm.
versus, a data broker's job is to sell data, right, or share data. And so they should be on top of it, and 10 days is reasonable. And I don't want anybody to think it should be that we're being unreasonable in that circumstance.
Yeah.
We're a business that's collecting data for they're not collecting the data to sell it. They're collecting the data for their customers so they can provide service to their customers in a different way. And they may do something inadvertently. So we're giving them more time for that. So I just wanted to highlight that.
Yeah, no, good.
And I would say too, that obviously Harmony is a useful thing to the extent that people want to act consistently and not have competing regimes, but it would be an odd thing if you guys were considering a statute that contemplated a 10-day compliance request and just it happened to be the case that you decided to do the Vermont Data Privacy Act this year, and that resulted in an expansion of that 10-day to some other figure. So there is an independent concern about harmony, alignment, eliminating confusion, but I wouldn't think it would make sense to lengthen this period just because you happen to do the Data Privacy Act this year. Like that would be a purely contingent reason for changing this, but something to think about.
Nicely done.
I'm going to stop sharing.
Further questions for John? All right. So again, anyone that wants to come in and testify, give us input, contact Andrew. Be taking testimony Thursday and Friday afternoons at 1 o'clock. Be on both days. And then also we'll be taking further testimony when we come back from town meeting break. So just put it out there. Any more questions for me? John, thank you very much. Again, thank you for all your work on this as well as me.
Thank you.
Very much appreciate it.